Hi, everybody. This is Advocate Lucinda, your empowerment lawyer. So, we're going to talk about the amended complaint. I am sure you heard a lot about the amended complaint, but we're going to talk about it from a different twist. Often, or sometimes, when a person files a lawsuit, they discover later on information that they did not have or they were not aware of when they initially filed the complaint, such as a hidden party or claims that had they had certain information, they would have included that particular claim that they left out. So we're going to talk about adding new claims and parties after the time to amend has passed. In other words, after the statute of limitations has run for the individual to add this claim or this party, or to include this claim or this party. So let's look at when and how to make this happen. So let's get started. So let's first look at the Federal Rules of Civil Procedure 15, because it sets forth the timelines for amending the complaint. Federal Rules of Civil Procedure 15A 1A allows the plaintiff to amend their complaint one time within 21 days of serving the original complaint, or at any point before the defendant answers the complaint. Let's look at Federal Rules of Civil Procedure 15A 1B. If the pleading or the complaint is one to which a responsive pleading is required, it's 21 days after service of a responsive pleading, that would be the defendant's answer, or 21 days after service of a motion under Rule 12B, E, or F, whichever is earlier. And of course, the infamous 12B motion is the motion to dismiss. Federal Rules of Civil Procedure 15A2 sets forth the following. In all other cases, a party may amend its pleading only with the opposing party's written consent or the court's leave. The court's leave refers to the plaintiff filing a motion asking the court to grant leave to amend the complaint. With regards to getting consent from defense counsel, don't just automatically take the posture defense counsel will say no. You need to ask. You have not because you ask not. So ask. Now, there is one other place to look, and that's Federal Rules of Civil Procedure 16B, the scheduling order. Now, after the complaint has been filed, the defendant has served an answer, the parties come together and participate in a scheduling conference. And in that conference, the parties discuss the management of the case. And one of the hot topics is discovery. Both parties can include information on adding claims and adding parties, and the deadline for amending. Always follow the scheduling order. there should be a scheduling order unless the jurisdiction in which the lawsuit is filed does not require a scheduling order. So let's get back to the heart of what we are talking about: amending the complaint. In other words, in order for a plaintiff to amend a complaint, to add claims or party, the amended complaint must relate back to the original complaint. And we call it the Relations Back Doctrine. Let's get into that more specifically. So the next question is, when does the complaint relate back? What does it look like? Let's go there. Let's look at the amended complaint as it relates to a new claim or defense. The claim or defense that is asserted in the amended complaint must have arose out of the conduct, transaction, occurrence that's set forth or attempted to be set forth in the original pleading, in this case, the original complaint. What are we saying? The conduct, transaction, occurrence that is in the amended complaint should look like the conduct, transaction, occurrence in the original complaint. And I've given you a case. I like to give cases to illustrate the issue in action. Chisler versus Columbus Med Equip, 2016, Ohio 3302. Let's see what the Federal Rules of Civil Procedure 15C says about changing a party. In order to amend a complaint to change a party, the party who is brought in by the amendment must have: 1, receive notice of the institution of the amendment that he will not be prejudiced in maintaining his defense on the merits. 2, the party must knew or should have known that, but for a mistake concerning the identity of the proper party, the action would have been brought against him. And you can also see this in action in Chisler versus Columbus Med Equipment. So here we have it. If all compliances are met, the amended complaint is treated as if the new claim and party were pled in the original complaint. And this is the Relations Back Doctrine.